Most people, I think, originally thought of Arizona versus United States as a case about federalism. In a way, it's really not about federalism. I mean, the reason people thought it was a case about federalism is that it seems to be a conflict between the state, Arizona, and the national government. But I think what the case is in fact about, or at least its lasting significance, concerns its holding about separation of powers, and especially executive power.
Good afternoon. I'm Jack Levin, a partner here at the law firm of Kirkland & Ellis, and also president of the American Jewish Committee's Chicago chapter. I'm very pleased to welcome this enthusiastic crowd to the Kirkland & Ellis Conference Center for today's excellent program, jointly sponsored by 4 organizations: the American Jewish Committee Chicago, the Latino Policy Forum, the Alliance of Latinos and Jews, and Kirkland & Ellis. Because America is a nation of immigrants, and because fair and humane treatment of all people is part of our basic fabric, the topic of immigration law strikes a responsive chord in all of our souls. We at AJC are committed to remedying the difficult problems inherent in the U.S.'s present immigration system. I personally believe that the best way to make the American Jewish community stronger is to make America stronger, and a smooth functioning immigration system will help achieve that goal. According to a recent study, comprehensive immigration reform that allows undocumented immigrants to come out of the shadows and into the mainstream of American life would boost the U.S. economy by $1.5 trillion over the next 10 years, while adding billions of dollars to our tax revenues. Just as AJC advocates for a comprehensive and positive solution to America's immigration problems, so do today's 2 co-sponsors, the Latino Policy Forum and the Alliance of Latinos and Jews. The Latino Policy Forum has long worked hard to ensure the well-being of the American Latino community and our society as a whole. And the Alliance of Latinos and Jews has been a force in Chicago's Jewish-Latino relations for almost 2 decades, building new and enhancing existing relations between the Jewish and the Latino communities by focusing on issues of common concern. And its newly elected chair, Keita Rodriguez-Bauer, is with us today. Before introducing our very talented speaker, I call on AJC's Immigration Task Force co-chair, the very capable Joel Greenberg, for an update on upcoming AJC immigration-related events. Joel?
Thanks, Jack. Hi, good afternoon. I'm Joel Greenberg, and I am the chair of AJC's Immigration Committee, the co-chair with Eva Lichtenberg. And the last time I was in this really wonderful venue was when we had the Bridging America conferences here, 3 separate occasions where we started doing the groundwork on immigration reform. People ask me often, why is immigration a Jewish issue? And I answer, it's an American Jewish Committee issue for the reasons that Jack said, because the American Jewish Committee has always felt that the civil rights of every person are significant to the civil rights of the Jewish community. We've always felt that since we started in 1906. We still feel that way. There is a Jewish answer which goes deeper than that, of course, and anybody who reads Leviticus and reads that strangers are to be welcomed and valued as we were once strangers in the land of Egypt. And we really feel that treating aliens among us as ourselves is the way that Jewish people should conduct themselves. And I really think that that's our main motivation for being involved in the immigration struggle. And a struggle it is, as you hear today. And when we started this a couple of years ago, it didn't look good, and some of us argued that politics can turn quickly, and I think things are changing. The recent national developments around immigration has made this front page news, as witnessed by everyday news reports and by the people who came out today, and we're so glad that you all came out. AJC's history in this involves the legal and involves the social and involves the community work. In the Arizona case, which we're going to talk about today in depth, we favored this decision as it was written, and of course we disagreed with the parts of it that we'll hear about today. We applauded the President for his executive order when he stopped deporting undocumented youth, in effect implementing what we had supported for so long, which was the DREAM Act. I think that'll have a great effect on the United States, and I hope that it gives some peace to some young people who are deserving of the peace that they have in this country, and they should have, and that they can reap some of the benefits of this country that most of them who are involved in this situation don't even know that they have a foreign country that they're from. AJC has supported the DREAM Act ever since it was first proposed, and we continue to support it, and we continue to fight for it. The Bridging America project is a project that reaches nationwide, involves immigration and reform in all its aspects. It's a nationwide initiative to build Latino-Jewish relations in support of immigration reform. I'd advise you to look, I'd suggest that you look at AJC Chicago website, which really has a lot of information about Bridging America. The Bridging America project, run by Ellen Carmel out of our office here in Chicago, has made the Chicago office of AJC really instrumental in immigration reform throughout the country, and I'd urge you to look at that. And you can sign on to the Bridging America Project Statement of Principles, which we've developed with our Latino colleagues, and you'll find some good principles there that we should espouse. So I thank you very much. I'd like to turn the program back to Jack, and we can get started talking about the case.
Two additional items before we turn to our main event. First, today is the opening of the Olympic Games, in case you hadn't noticed. But since the International Olympic Committee has declined to recognize and commemorate in any way this 40th anniversary of the 1972 despicable murder of 11 Israeli Olympic athletes at the Olympics, I propose that we take just a moment of silent remembrance now. Second, you are all invited to AJC next Thursday morning when we will host Israeli Supreme Court Justice Salim Jubran. That's Thursday, August 2 at 8 a.m. at AJC's downtown Chicago office for a discussion about the Israeli Supreme Court's role in Israel's democratic society. You can register on AJC's Chicago website, so ask any of the AJC officials here today for more details. Now, to the main event. Our speaker today, Professor Eric Posner, has a very modest resume, so my introduction should not take long. Eric is simply a summa cum laude graduate of Yale College, a magna cum laude graduate of Harvard Law School, author of, at last count, 14 books. I'd hold up my fingers, but I don't have 14 fingers. 14 books on topics as diverse as the limits of international law, law and social norms, the perils of global legalism, and terror in the balance, some of which have been translated into such diverse languages as Japanese, Chinese, and Arabic. Author of approximately 140 published articles and over 65 newspaper op-eds and commentaries, dealing with just about any topic you can identify. Now, Eric is at this time 46 and a half years old. So based upon the number of his published scholarly works, it's pretty clear that he began writing well before his second birthday. We're also proud to mention that as Eric's day job, he is the Kirkland and Ellis Professor of Law at the University of Chicago Law School. And most relevant to today's discussion, one of the topics on which Eric's current research and writing are focused is immigration law. Finally, let me mention that Eric Posner, our speaker today, you'll keep in mind, is the son of Federal Court of Appeals Judge Richard Posner, one of America's most famous, brilliant, and independent federal judges, with whom I had the good fortune to serve, both on the Harvard Law Review and thereafter at the United States Department of Justice. So Eric, come forth and tell us what the U.S. Supreme Court did and didn't do in its recent Arizona immigration decision and the case's implications for the future.
Thanks, Jack. So I'm going to talk about Arizona versus United States, and then I'll say something about the broader implications of this case for immigration law. So this, as I'm sure most of you know from the news accounts, this case involved a statute that was enacted in Arizona. The statute's often called SB 1070. And the statute has basically four major provisions that the Supreme Court addressed. The first one is that when a state police officer stops someone or arrests that person and has a reasonable suspicion that the person is in the United States without a proper visa or other papers, that officer should make a reasonable effort to determine that person's immigration status. Presumably, the way that police officer would do that is make a call to ICE, the Immigration Customs Enforcement Agency. Second provision of the statute is that the state police officers must arrest anyone who has committed a crime that would, under federal law, require the person to be deported, a deportable crime. The third provision that was addressed in the case is one that would make working without a visa or applying for a job without a visa a state crime or without other immigration authorization. And the final provision is one which says that if you're in the United States illegally and you're in Arizona, then that is a crime under Arizona law, so you can be arrested, prosecuted, and punished. So that's the statute, and Arizona passed the statute for a number of reasons, some good, some bad. As you know, Arizona is a border state. People who live there are concerned about illegal entry. They complain that federal enforcement of the immigration laws is too lax, and as a result, they feel like problems associated with illegal immigration fall especially heavily in Arizona. Well, what are those problems? They say that illegal immigration is associated with greater crime. And probably, there's an economic motivation as well, concerned that illegal workers may suppress wages and maybe cause unemployment of citizens and lawful residents. Let me just say a few more words about crime. Generally speaking, people who are here illegally are no more likely to commit crimes than citizens are. In fact, they're probably less likely because, of course, the consequences are more serious. But it is the case that there's criminal activity associated with the process of bringing people over the border. And there's some violence, and sometimes it's associated with drug crimes as well. So I suspect many of the people in Arizona were surprised at the outcry that this statute caused, and I'll get into the reasons why. But why did the statute cause an outcry? Well, first of all, there was legitimate concern that the statute would lead to racial profiling. of U.S. citizens and lawful residents. It maybe it would heighten anti-Hispanic animus in Arizona and other parts of the country. There were concerns, in addition, more broadly, that maybe this statute would contribute to a hostile environment for lawful migrants, and that's not the sort of environment that we want to create in this country. And then I think there's yet another concern, maybe in a smaller group of people, but these are people who think that the immigration laws in the United States are excessively harsh and unfair to Mexicans in particular, and that the Arizona law would just exacerbate the problem by making enforcement even harsher and more unfair. So the U.S. government brought a challenge against the Arizona statute in federal court, and the government's argument was actually quite simple. They say under the supremacy clause of the Constitution, if there's a conflict between state law and federal law, then federal law prevails. The Arizona statute conflicts with federal law, therefore it's unconstitutional. That was essentially the U.S. government's argument. Arizona made the following response. They say the statute didn't actually conflict with federal law. It was fully consistent with federal law and indeed reinforced federal law. And in particular, let me go through the four provisions. First of all, consider the provision that says that if a state police officer stops or detains someone, he should check that person's papers. Well, it's already the case that police officers check people's papers. They do it frequently. There is formal cooperation between the U.S. immigration authorities and the states, under which the immigration authorities encourage the states to check people's papers. In fact, under one program, which has been implemented in, I think, most states, whenever state police officers or city police officers arrest someone, they send that person's fingerprints to the Department of Homeland Security to determine whether the person is here unlawfully. And Arizona said, we're just acting consistently with the general federal goal of enforcing the immigration laws. As for the second provision, which requires state police officers to arrest anyone who's committed a deportable offense, a crime that would justify deportation or removal under federal law, that again is consistent with federal law, because the whole idea of federal law is that if you're here lawfully or unlawfully and you commit a serious crime, then you have to leave. And all that the state statute adds to that is that now state police officers will be involved in arresting those people. Presumably they would turn them over to federal authorities. And if the federal authorities decided not to deport them, that's their decision, but the state law doesn't interfere with it. The provision which says that if you work in violation of the immigration laws, you've committed a state crime, seems also to be consistent with federal law, which, after all, prohibits people who are here illegally from working. Indeed, even people who are here legally often cannot work. Certain visas will allow you to come into the United States, but not to work there. So again, Arizona law reinforces the federal immigration regime, and the same thing can be said about the final provision of the statute, which says that if you are here unlawfully, and in Arizona, that's a violation of Arizona law, that's a crime. Well, you're not supposed to be here unless you have a visa. This just lends Arizona's enforcement resources to the U.S. government and makes it more likely that such a person will be punished and maybe ultimately deported. So to sum up, Arizona argues that their law is consistent with federal law, in fact reinforces federal law, and so there's no reason why federal law should preempt Arizona law. And then they go farther and they make another point, which is that we live in a federal system. Arizona is a sovereign state within the constraints set forth by the U.S. Constitution. It has a sovereign interest in maintaining order and controlling its borders. And so, given that extra interest of Arizona, it's unfair and wrong to preempt, for the federal laws to preempt state law. I mean, ultimately, from Arizona's perspective, all that's going on here is that the federal government is not enforcing federal law and all that Arizona is doing is lending its own resources to help enhance enforcement of federal law. The Supreme Court mostly rejected Arizona's argument. By a vote of 5-3, the court struck down all of the provisions except for the first one I mentioned, the one that authorizes police officers to check people's papers. And even in that case, the court hinted that law in practice may be unconstitutional, as I'll explain in a moment. The Supreme Court starts off by pointing out that Congress has the power to regulate migration. Under the Constitution, Congress has the power to establish a uniform rule of naturalization. That's been interpreted to give Congress authority over migration. And in addition, the court has held in the past that the national government has a sovereign interest in controlling migration and generally in conducting relations with foreign nations. One of the points that the court has made over and over again is that we don't want a country with a complaint against the U.S. to have to deal with 50 sovereigns. And so if Arizona has its own immigration policy and that upsets Mexico or some other country, and Mexico goes to the U.S. government to complain, it would be awkward if the U.S. government said, well, we can't do anything about it. You need to talk to Arizona or any other state which passes immigration laws that other countries object to. So Congress has used this power. It has passed a massive comprehensive immigration code. This code specifies, who gets in and who doesn't get in, and what happens to those who get in, their rights, and also with respect to people who are not admitted but enter anyway, what will happen to them, right? So this is a very comprehensive code. And an additional point, which I'm going to come back to, is that because of the nature of the migration problem, it requires a great deal of discretion to enforce that code. So for example, there are thousands of millions of people in this country who should be removed under federal law, who are here illegally, but there's just not enough resources to remove them all. The executive has to decide how to use those resources, who to give priority to. And the executive has to take into account things like, what's going on in other countries. You don't want to remove someone to a country that's in the middle of a civil war, for example, or you don't want to remove someone if there would be great humanitarian cost. So all that discretion has been committed to the executive. So there's all this, so we've got this code, and now let's turn to the Supremacy Clause. Now it's true that the Supremacy Clause says that if there's a direct conflict between state law and federal law prevails, but it's also been interpreted more broadly than that by the Supreme Court over the years. The Supreme Court has said that even if there's a conflict between a state law and the overall purpose of a federal statute, the state law is superseded. In other words, even if they're in a kind of narrow sense consistent with each other, if we think that the state law would interfere with the overall purpose of Congress in enacting the federal law, then the state law supersedes the federal law. So then the court, after making these general remarks, turns to the four provisions that I've mentioned. Let me start with the provision that says that it's a state crime if you are in Arizona and you're not authorized. Now it's true the court says that this, in a sense, duplicates and reinforces federal law, but the problem is under federal law, the U.S. executive is given a lot of discretion to determine who to remove and who not to remove. State law is going to conflict with that judgment. So if there's a class of people that the president thinks should not be removed, and then the state throws them into jail, that's going to interfere with the enforcement of the federal system. Take next the provision that says that it's a state crime to apply for work or to work as an unauthorized alien. Again, in a narrow sense, it's consistent with federal law, although there's an interesting twist here, which is, although it's a federal crime to employ an unauthorized worker, it's not actually a federal crime for the worker to work for the employer. In other words, you can punish the employer, but you can't punish the worker, at least as a criminal matter. And there may well be a good reason for this. The immigration law makes very fine distinctions between different types of migrants. And so if the idea is not to be too harsh on the illegal worker, the state law conflicts with that. Same basic points can be made about the provision making it a crime to apply for work, or about the provision that authorizes the state police officers to arrest someone if he has probable cause to believe that that person has committed an offense that's deportable under American law. Again, the idea of the immigration system is that the executive will pick and choose among which people who've done that should be removed. The state law makes it mandatory and automatic. And then finally, there's the provision that authorizes the state police officer to check the status of someone that they've detained or stopped. And the court, Justice Kennedy, says, okay, well, this provision may well be consistent with U.S. Immigration law. After all, it's already the case, and it's understood to be the case, that state law enforcement officers can check the papers of people that they detain. And in fact, they're often supposed, as I mentioned before, they're supposed to call up ICE and see whether the person is here unlawfully. But Kennedy went on to say that if, in fact, this statute is implemented in a way that is discriminatory or that causes disruption to people's lives, it could very well be unconstitutional in practice. And he gives the example of if the police, stop someone for jaywalking, and then say, well, normally they just write a ticket, but then they say, okay, but you're going to have to sit here for 4 hours while we call the ICE and wait for their response. That may well be unconstitutional. By contrast, if they arrest someone for drunken driving and the person would normally be kept in jail overnight so that you could call ICE without disrupting what would normally happen to this person, that may well be justified. But many people who've read this feel like it's going to be pretty easy for advocates for immigrants to challenge this provision the way it's used in practice. Either that, or it's not going to be of much use to the police in Arizona. Now, Justice Scalia wrote one of the 3 dissents, and his dissent got a lot of attention in the press because he brought up the DREAM Act, or in fact, President Obama's decision to in effect implement the DREAM Act, even though it was not enacted by Congress. So under President Obama's order, the immigration authorities will not remove basically young people under 30, who've been in the U.S. for at least 5 years, who came to the U.S. Before they were 16, and either are in school or have graduated from high school or are a veteran, or as long as they haven't committed a serious crime. Okay, so why does Scalia bring this up? After all, President Obama's action is not the subject of the litigation. But the reason he brings it up, I think, is that he's pointing out that there's really no conflict between Arizona law and the statute as written. The conflict is between Arizona law and President Obama's enforcement priorities. And so he says, well, this doesn't implicate the Supremacy Clause. The Supremacy Clause is about a conflict between the statute and the federal statute and the state statute, not a conflict between the state statute and the policy of the executive, the way that the executive decides to implement the federal statute. Now, what I find interesting about this is that most people, I think, originally thought of Arizona versus United States as a case about federalism. In a way, it's really not about federalism. I mean, the reason people thought it was a case about federalism is that it seems to be a conflict between the state, Arizona, and the national government. But I think what the case is in fact about, or at least its lasting significance, concerns its holding about separation of powers, and especially executive power. As Scalia points out, there's no real conflict between state and federal law, but there is a conflict between state law and the president's policy. And Justice Alito, in his own dissent, makes this very clear. He says, the United States' attack on this law is quite remarkable. The United States suggests that a state law may be preempted, not because it conflicts with a federal statute or regulation, but because it is inconsistent with a federal agency's current enforcement priorities. Those priorities, however, are not the law. They are nothing more than agency policy. I am aware of no decision of this court recognizing that mere policy can have preemptive force. And I think Alito is quite right in pointing out that that's what's going on in this case, but I also think he's wrong to find this to be quite remarkable, as he says. It's not remarkable at all. It's the system that we live in. And so what one can do here is contrast what you might call the Madisonian view of separation of powers, which is what Alito and Scalia are alluding to, and our modern system, which I would call a system of presidential primacy. So under the old separation of power system, Congress makes policy, which is embodied in law, and the executive passively implements the policy. He just is an honest agent who follows Congress's orders. Those orders are embodied in the law. So when we talk about supremacy clause, what we're concerned about is a conflict between federal policy and state policy. And we sort of assume that federal policy will be embodied in the statute because Congress is the body that makes federal policy. But under the modern system of presidential primacy, Congress plays a more limited role. Congress is more in the background. You might think of Congress as a bit like the board of directors and the president as the CEO. In today's world, really starting probably with Teddy Roosevelt or definitely by the time we get to FDR, the president makes policy subject to broad constraints laid down by Congress. People sometimes, many people have criticized this development under the rubric of the imperial presidency, a complaint made by Arthur Schlesinger back in the early 1970s. But it's just a fact that this is how our government works. The president has enormous authority over the use of military force, foreign relations, and to a large extent internal security. And for that matter, the entire regulatory state, going back to the New Deal, is premised on presidential discretion. Congress sets up these agencies and funds them, but provides quite vague instructions to the president, allowing him to set policy, again, within certain parameters. And this is true for immigration law as well. In fact, it's always been true for immigration law, even more so than these other areas, like, say, environmental law. And so what happened here is the Congress, Congress didn't pass the DREAM Act, it didn't do all kinds of things, but it has given the president general authority to regulate immigration. And the only way to embody the presidential, you need to interpret the supremacy clause in the light of the system of presidential primacy that we have. And once you do that, you realize that if there's a conflict between policy as embodied in the president's orders rather than the statute, and the state statute has to yield. That's just how our system has evolved. Well, what does this have to do with immigration policy in the United States? I think it has quite a bit to do with it. Arizona passed this statute because it believed that there's a problem in this country, a problem of illegal immigration. Many people agree with Arizona, not everybody does. There are an estimated 11 to 12 million undocumented aliens in this country. And the question is, what to do? And for the people who think that this is a problem, they blame the problem on the federal government for not engaging in sufficient enforcement. Okay, so they say, oh, this illegal immigration is terrible, it leads to crime, it leads to unemployment, it leads to congestion. The federal government should do something about it. It hasn't done something about it. This is a failure. It's a political failure. And people in Arizona would say, that's why we're acting. That's why we're trying to do something. But there's another view that you can take about illegal immigration, which is that it's not really a problem. In fact, it's, in a way, the implicit policy of the U.S. government has been for 40 years or so, or more even. And the way it works is this. This country benefits a great deal from unskilled labor. And generally speaking, people welcome unskilled labor into this country from other countries. The people who come here work in factories and they work in farms, and these transactions result in benefits for everybody. The U.S. consumers benefit from lower prices, and the migrants benefit from receiving wages that are higher than they would receive in their own country. Now, some people are inevitably harmed, competing workers, but there's not that many workers in the United States who really want to do the sort of unskilled labor that migrants do. Now, the U.S. government then has essentially, the reason why it doesn't enforce the immigration laws very strictly is not that it's too expensive, it's just a policy decision that this migration will be tolerated. And indeed, from time to time, the government issues amnesties and other laws that essentially says, well, you've been here for a long time and you've worked and you have not committed crimes, so we'll let you become U.S. citizens. It seems to me a kind of an implicit acknowledgement that the system is in the interest of the public, at least according to the political class. At the same time, the immigration resources are targeted to migrants who do not serve the national interest, those who commit crimes, for example. And so what we have is a system in which we let lots of people in, and then some of them are productive members of society, and eventually they're allowed to stay, and eventually they'll become lawful members of society. And others who do not fit in for whatever reason, those people will be removed. And it seems like actually a clever, although somewhat underhanded way of advancing economic prosperity. Why not just embody this in the law? Well, I think part of the reason is that the Supreme Court has created due process constraints that apply to people who are here lawfully but do not apply to to people who are unlawfully. So the government has responded by allowing unlawful people to come in because it's easier to remove them. Still, you'd think that if this is a good system, it would be better if it were legalized. After all, what we end up having is an underground economy, lots of people who the government can't keep track of. Under the new health care law, a lot of these people won't get health insurance. So wouldn't it be better to have something like a formal guest worker program? And for all of the vituperation and acrimony about immigration, both parties more or less agree about this, that they more or less agree that something like, at least the moderate parts of both parties, agree that something like a guest worker program would make sense. That is, you let people come in for a few years, and then they leave, and maybe some of them who put down roots would have a path to citizenship, and everybody would be, lawful. Everybody would be known, everybody would pay taxes, and so forth. The big problem, though, the big stumbling block before such a policy could be implemented is the 11 to 12 million undocumented aliens. What happens to them under this system? And again, I think the pragmatic people in both parties say, look, there's no money or political will to deport 11 to 12 million people. It costs trillions of dollars, and it would disrupt society in many ways. It's just not going to happen. So the 11 to 12 million people have to be given a path to citizenship. Certainly those who have worked and assimilated to some extent and haven't committed crimes. So I think that's the sort of pragmatic goal, the direction that very slowly the country is going. But there's a big stumbling block. The problem is, many people in this country, I don't know whether it's a majority or just a large minority, they're skeptical about immigration. They're not opposed to immigration altogether, but they're less enthusiastic about other people. And they're particularly skeptical about this plan, this sort of pragmatic plan that I've described, because they don't believe the federal government will enforce it. They say, look, you've never enforced the immigration laws before. Under your new plan, it would have to be the case that someone who came in and settled here without, getting the guest worker visa would have to be deported. But why should I believe that you're going to deport that person? After all, you haven't deported the 11 to 12 million people who are here. And I think that both the Bush and the Obama administrations have tried to respond to this argument. I think that's why both administrations, going back to the early 2000s, have ramped up enforcement. They're trying to make this promise credible by showing the skeptics that, in fact, the federal government is able and willing to control the borders. So they built this big wall, right, on the Mexican border, and they've hired hundreds of thousands of border guards, and they've conducted more raids. Both administrations have done this. And I think the idea in doing this, it's not like some kind of blind attempt to enforce the immigration laws. They're trying to build up credibility to persuade the skeptics that a formal guest worker program or something like that, along with a path to citizenship for people who are already here, would be enforced. Now, these type of enforcement efforts are hardly uncontroversial. They've created a backlash. They're harsh. The wall has, caused people to try to enter the U.S. through a desert, a harsh desert, the Sonoma Desert. Many people have died. So there's a bit of a political backlash. And this means, of course, that the government has to act carefully. But if it does, if it's not strict enough, then again, the skeptics are going to say, well, why should we believe you? So there are a couple ironies about this Arizona statute. One is that, the U.S. government might have taken a different approach to it. They might have said to the skeptics, look, even if you don't believe that we're going to enforce immigration law, at least the states will. Or the states will enhance our enforcement efforts. And so you should, not be so skeptical and let us go ahead with desirable immigration reform. Instead, the U.S. government challenged the statute. And then again, the second irony is that if the Supreme Court had come out the other way, again, it might have appeased the skeptics by telling them that they could always use state legislatures to try to control entry of unauthorized people. So if the court had upheld the law, then the immigration skeptics might have been open to more federal reform, so that we could ultimately lead to this goal of having a kind of a rational system with something like a guest worker program along with a path to citizenship. But because the court struck down the law, I think that the skeptics may well be unwilling to agree to much needed federal legal reform. And with that not very uplifting conclusion, I'd be happy to take some questions. Yes?
Just in a general sense, the immigration law is what we call quasi-criminal as opposed to criminal. So how does the state of Arizona come to the conclusion that they're enforcing criminal law by their statute?
I was asked to repeat the questions for the camera. So the question is, given that the federal immigration law, as I would describe it, it consists of both criminal and civil provisions. And Arizona's statute is entirely criminal. It creates crimes, and it creates authorization for the police officers to enforce federal immigration law. And I think what Arizona would say is that the general goal of federal law, as Arizona interprets it, is essentially to deter people from entering the U.S. territory who have not received permission from the U.S. government. And now there's a question, why does the U.S. government use a mix of civil and criminal provisions to promote that goal? And so I think what Arizona would say, well, some things work in some situations. We don't want to maybe penalize some people too much. But ultimately, that's subordinate to the ultimate goal of deterring people who have not been admitted from actually entering the country. And so we'll use criminal provisions to strengthen the law. And I think maybe the assumption of your question, which I agree with, and this is what the Supreme Court held, is that in fact Congress chose carefully the mixture of civil and criminal sanctions. And so if you layer a state criminal sanction on top of a civil sanction, then you might create excessive deterrence or harsh results that we don't want, maybe because they're inhumane, maybe because it will offend other countries, but these are the sorts of judgments that Congress should make, not the states. Jack?
Just run up here and say it so you don't have to repeat it.
Okay.
There are so many harsh aspects of the current federal system that make it inequitable. Just as an example, and tell me if I'm wrong in these examples, so you have a couple who come in illegally. They bring along with them one small child, 1 year old. When they arrive here, they have one more small child. Now you've got three different sets of rules. The people who came in as adults, even under the current system, they're subject to deportation. the child they brought with him, if they can stay long enough for him to have him or her to have had 5 years, et cetera, and no criminal background, that child can stay. The one that they had while they were here in this country, that one, being born on U.S. soil, is automatically a U.S. citizen and couldn't be deported. And these kind of anomalies are things that, unfortunately, we can't get Congress in its current state of gridlock to address with some sort of rational or comprehensive system that's fair to the people. And if you could comment on that.
Well, I think to some extent, this type of inequitable result is simply inherent in legal regulation. Lines have to be drawn. And one can understand why, as a matter of public policy, we might think that people who have stronger ties with the country should take precedence over people who have weaker ties. There's also a concern about gaming, people coming in, having a child, taking off, which apparently happens from time to time. And so what Congress has to do is provide some very bright line rules. Now the problem is, the bright line rules reflect sort of abstract concerns about the degree to which you're tied to this country. But inevitably, they might miss something, like the fact that you're a part of a family. And I'm not sure whether it's even possible to design rules that would satisfy everybody, that would be humane under all circumstances. But in a way, that's the point. And Justice Kennedy makes this point as well. Because the rules are, to some extent, very broad and will lead to arbitrary results, we have to fall back on enforcement. And the president can take into account these sorts of hardships. And there are a bunch of sort of hardship waivers and so forth that the immigration authorities are willing to grant under certain circumstances. So what you need is something like a common law case-by-case system to deal with results that are harsh in particular circumstances. I don't think the problem is that the current statute's not comprehensive. It is comprehensive. It tries to address everything. The problem is it's outdated. It doesn't deal with the current problems that we have. And I think what will happen eventually is that a newer, better statute will be enacted that addresses some of these problems, but that will create a whole new set of problems that the legislators don't anticipate. And again, there will be a great deal of reliance then on the executive branch to use discretion to prevent individual cases of hardship. Yes?
We had a formal guest worker program in this country at one time. I think it was called the Posner program on the West Coast.
Right.
Was that not successful? Or it was successful, as I understand it.
Well, it was not success. I mean, it has a very bad reputation. Sorry. The question was about the Bracero program, which was a formal guest worker program that existed in the United States in the Southwest earlier in the 20th century. I don't remember exactly the dates, but probably certainly the 40s and 50s. Yeah, all the way through the 60s. And And all right, so it reached into the Midwest, and this was people would come over and work in farms, but my understanding of this is that the immigration community did not like the Bracero program. I believe it may have been implemented in an arbitrary way, possibly insensitive way. Guest worker programs in general, many people are skeptical about guest worker programs in general because they create sort of the problems that Jack has mentioned. This is what happened in Germany, where guest workers came in, they had children, they never left, and they developed roots in the country, but they never became citizens. Although in recent years, Germany has started granting citizenship rights to them. So that has always been the knock against guest worker programs, and that's why if you're going to have a guest worker program, it has to be enforced, which means that when it's time for you to leave, you have to be forced to leave. If the government cannot credibly commit to doing that, then I don't think there will ever be any acceptance for a guest worker program. Yes.
What percentage of the 11 or 12 million are Latinos, and is everybody treated the same?
Well, definitely not everybody is treated the same, right? So, I mean, as a formal policy, the question is what percentage of the 11 to 12 million undocumented aliens are Latinos, and are they treated the same? The answer to the second part of the sentence is no. So the immigration authorities have this specific policy. We're going to go after people who commit crimes, serious crimes. And I believe that they say that they have the resources to remove 400,000 people per year. And so they're focusing those resources on dangerous people. I don't know what percentage of unauthorized aliens are Hispanic. Does anybody? It's large, but I don't know the exact percentages.
It's about 60%, I believe, nationally.
60%.
More or less.
Okay.
No one knows for sure.
Right, exactly. I mean, that's the problem. Is nobody really knows what the number is. Also, these are estimates. Yeah.
What I meant was, by being treated the same, are Latinos treated more harshly? Are they looking for them more than people from other?
Oh, I see. Well, certainly not as a matter of formal legal policy, but in practice, it's quite possible. Because when the immigration authorities are looking for people to deport, they're going to single out people who seem more likely not to be citizens, and Hispanics and Hispanic neighborhoods may well be a more visible target than other types of migrants who are scattered around the country. But certainly, there's a strong view that that's the case. Yes.
Yes, it seems that the reason why the one provision withstood the challenge was because it involved cooperation with the federal government. Basically, I think it involved the Secure Communities Act, right, which is the short name for the longer name that says that we report you to ICE and we arrest you. Then I understand that the federal government, within 2 days of the decision, canceled their agreements. Just voided out their agreements with Arizona with respect to secure communities. So do you think that that is the underpinning for the validity of Section 2B and it will fall without that?
So the question is whether, it's a complicated question, let's see if I can reproduce it. The provision, so we're talking about the provision in the Arizona statute that authorizes, basically authorizes, doesn't require police officers, but authorizes them to check the papers of people that they detain. Now, meanwhile, there's this program, Secured Communities, and there's another one as well. There are a couple of these programs floating around, under which the states and the federal government enter into an agreement. And this agreement says that when the states pick up somebody, they will check with the federal government to see if that person is in the country lawfully. So it was pointed out to me, I didn't know, that the federal government canceled the Arizona agreements right after the case was decided. So why did they do that? Well, they may well, I mean, I think, there could be political reasons, there could be policy reasons. A policy reason might be that they don't trust Arizona. They just don't trust Arizona to administer this program in a fair way. The political reason may be that this will be a way to ensure that in the future this statutory provision will be struck down, which I guess was the point of your question. So in the future, when somebody challenges this statute as applied in a particular case, Arizona won't be able to say, well, we're just cooperating with the federal government pursuant to the Secured Communities Program, because they're not doing that anymore, right? So maybe that'll be a method to get this provision struck down.
One more question.
Okay, yes, back. Is your question? Do you still have a question?
Yeah.
Yes.
I just think it's important, just going kind of right back to secure communities and going back to the analysis that Arizona claimed that they were just enforcing federal law. Secure communities only allows them to for documentation of people that they've already detained, not to stop people who they suspect are unlawfully present. So that's a pretty big distinction, and I think that's why that provision was knocked down. And so I just think that's important to keep in mind as you're talking about it, because it seems like that's being lumped together, and those are completely different concepts. But also, I guess my question is, do you have any insight as to why the Department of Justice did not include the discriminatory practices that are going to come out of Section 2B in their argument. They were asked at the beginning of oral arguments whether that was going to be part of it at all, and there was no reason that they needed to keep it out, but they chose to, and it just I don't understand why that was the case.
So the question is why the Department of Justice didn't argue before the Supreme Court that this provision we've been discussing would be implemented in a discriminatory way, either as a matter of logic or...
So they could have filed them together, and instead they filed them separately, the discrimination and the current case.
Yeah.
So, and when they were asked by, I forget who asked, I think Celia asked if they were going to talk about discrimination at all, and they said no. They could have said that these things are not something that you can separate and that you have to keep them in mind when you're making your decision, and they chose not to.
Yeah, I just don't know the answer. Should I take one more question? Sure. Okay. Yes.
Yes. In relation to the outcome from the Supreme Court, can you give us your perspective from what you think the influence is going to be in the other, for example, 5 states like Indiana, Alabama, and Georgia? How is that going to influence the outcome of the pending legislation there?
Well, certainly, I think states will be reluctant now to pass statutes that target migrants. Now, there'll still be political gains from doing it, and of course, even in this case, the Supreme Court doesn't rule out all such types of legislation, and there are precedents that allow states to do some immigration regulation. But I think clearly, I think it's already taken a little bit of the wind out of these attempts to use state legislation to target migrants, whether lawful or unlawful, and I do think it's an important case for that reason. It will have an impact.
Thank you.
So to close, I'm Sylvia Puente, and I'm the Executive Director of the Latino Policy Forum, and we're delighted that you were all able to be here with us today. I really want the Latino Policy Forum, for those of you that may not be as familiar with us, is a small nonprofit here in Chicago with a very big mission of promoting access, equity, opportunity, and investment for the growing Latino community. And you all know that the community has grown tremendously, but resources and investment have not kept pace with that growth in early education, in housing, and in immigration, which are the issues that the Latino Policy Forum focuses on. We also focus on strengthening the overall leadership within the Latino community, all with an understanding that advancing Latinos advances our shared future. So we're very pleased and delighted today and grateful to the American Jewish Committee for asking us to partner with them on this event today. We really appreciate the partnership, the support that we have, and that they are some of our most fierce and loyal immigration advocates. We also want to thank the Alliance for Latinos and Jews and Geta as the chair of that for this partnership, and Kirkland and Ellis, not only for this wonderful facility, but for the really good lunch. Thank you. So allow me, if you will, to take just a couple of moments, Dale, to respond to a little bit of your question from my point of view about is there unfair or disproportionate focus on the Latino community in this. And while this is, of course, a political judgment on my part, but I think borne out in the facts and in the dollars, we know that about half of unauthorized migrants in the United States have crossed borders, and about half have flown and overstayed their visas. Yet the millions and millions and billions of dollars that we have put into this issue have primarily been along the U.S.-Mexico border. We have certainly not put equal investment of resources or personnel into those folks that overstay their visa. And we also know that when we look at the over 1 million deportations of broken families that this current presidential administration has undertaken, that the overwhelming majority of those families are families from Mexico and Latin America, and not the other half of the unauthorized population that resides in the United States. So With that, then, let me say that in the context of this conversation, it is also my eternal frustration that as this debate rages around the nation in this current political environment that we were in, that so often I feel that we blame the victim. And we don't spend enough time in our discourse, in the media, in presidential debates, and all speaking as to why people have come to the United States, the challenges of what's happening in their country of origin, but we also don't focus on the employers who hire them, nor do we focus on how the U.S. was complicit in looking the other way in the 90s when the bulk of this migration happened, when we were in happier economic times. And this low-wage labor really helped, in my opinion, to sustain an American middle-class way of life. Every piece of lettuce that we eat, most of our food crops, a lot of our landscaping, many of our nannies, many of our small manufacturing businesses, in fact, many of our larger businesses have really benefited from the low-wage, undocumented migrant labor. And we don't have that conversation enough, I think, in the broader debate, rather focusing on the individual and not looking at the larger and greater benefits that have accrued to the economic boom that this country faced in the 90s and the 2000s. So that's just to say that this is obviously a very rich discussion, a very difficult conversation, and a very complex conversation. And that as we think about this, that it really is important to fix our broken immigration system. The Supreme Court decision was one little piece of what's necessary, but not nearly what we need to have. The recent decision that allows undocumented children who were brought, or young adults who were brought to this country as small children, is only a temporary solution. And again, is just one piece of our broken immigration system. So I really want to thank you again, thank our hosts, and join me again in just giving thanks again to Professor Posner for his insightful comments.